good day everyone. By the way, I'm Marian Verano and today my report is about diplomats versus consuls. So there are two kinds of consuls. Number one is consulis missi and number two is consulis electi. So when you said consulis missi, so professional or career consuls who are nationals of the sending state and are required to devote their full time to the discharge of their duties. So sila ay mga professional na consul na nagtrabaho ng full-time para sa kanilang bansa. So, sila yung mga taong nagmula sa parehong bansa na kinakatawan nila. So, number 2, consulis electi. So, may or maybe not be nationals of the sending state and perform their consular functions only in addition to their regular callings. So, sa kabilang banda, so yung consulis electi, so maaring or hindi maaaring maging mamamayan sa nagpapadalang estado or they have other jobs besides being a consul and only perform consular duties part-time. So for example, so ang consul electi could be a teacher or business person or who also helps out with consular when needed. So this means that consuls missi are full-time professional consuls from sending state, while consulis electi are part-time consuls who may not be from the sending state and have other job as well. So let's go to the duties of consuls. So number 1, protection of the interests of the sending state and its nationals in the receiving state. So example nito is to make sure that their policy is being followed and the citizens in that sending state or in that state is protected. So number 2, promotion of the commercial, economic, cultural, and scientific relations of the sending and receiving states. So this means that they help to improve the relationships between the two countries in areas like the business trade, the culture, and science. So they work to make sure there is a good communication and cooperation between the two countries in these areas. Number 3, observation of the conditions and developments in the receiving state and report the same to the sending state. So this means sila yung mga mata at tenga ng isang bansa at sila yung nagre-report kung anong nangyari sa bansang kanilang pinuntahan. And number 4, issuance of passports and other travel documents, nationals of the sending state, and visas or appropriate documents to persons wishing to travel to the sending state. So, sila yung mga mag-i-issue ng passport at ibang mga travel documents or mga visas at mga taong gustong bumisita sa isang bansa. And number 5, supervision and inspection of vessels and aircraft of the sending state. So, sila yung mga responsable para mag-inspeksyon sa mga karga if wala bang ginagawang illegal, ganun, or make sure safe cargos and documented. So let's go to sources of authority of consuls. So number 1, letter patent or letter D provisions. And number 2, exequatur. So when you, and the number 1, letter patent or letter D provision, so which is the commission issued by the sending state. So this means like for me, so this like a formal letter or document from the consul's home country giving to act as a consuls in another country is just like a kind of official job offer. Number 2 is exequatur. So which is the permission given them by the receiving state to perform the functions therein. So this means like this is something like a permission from the country where the consul will be working to allow them to do their job there. So it's just like a sample of approval from the host country. And let's go to the immunity of consuls. So, consuls enjoy their own immunities and privileges, but not to the same extent as those enjoyed by the diplomats. So, it means like so consuls are like diplomats, but they don't have many special protection. They still have some important privileges though. So number one, like inviolability of their correspondence, archives, and other documents. So this means like, so consuls can keep their letters, files, and other papers in private. And number two, so freedom of movement and travel. So of course they can go wherever they want or travel or move freely and not to be stopped by the police. And number three, immunity from jurisdiction for acts performed in their official capacity. So this means like they can't be punished for it by local government. So number four, so exemption from certain taxes and customs. So this means like they don't have to pay certain taxes or fees. Okay, let's go to the liabilities of consuls. So arrest and punishment for grave offenses and may be required to give testimony subject to certain exceptions. So note, members of a consular post are under no obligation to give evidence in the following situations. So A, concerning matters connected with the exercise of their function. So this means that they don't have to tell them related to do their job and how they do their job. And B, to produce official correspondence and documents. So this means like hindi nila kailangan na ipakita yung mga dokumento or mga komunikasyon nila. And C, to give evidence as expert witness with regard to the law of the sending state. So hindi nila kailangan magbigay ng ebidensya just because let's say example, I'm from US citizen, so they can't ask about US laws. So if that person like not to act to explain the US laws or which sending states you came from. So let's go to diplomatic immunity versus consular immunity. So differences in privileges of immunities of diplomatic envoys and consular officers from the civil and criminal jurisdiction of the receiving state. So number one, a diplomatic agent shall enjoy immunity from the criminal jurisdiction of the receiving states. He shall also enjoy immunity from its civil and administrative jurisdiction. This means like in simple terms like a diplomatic agent is someone who works for another country and is sent to represent their government in a different country. That person is protected from being persecuted for crime in the country they are working in. So I think under below of this one is something like certain situations where diplomats may not be protected from legal actions in the country they are working in. So which is a real action relating to private immovable property situation in the territory of the receiving states unless he holds it on behalf of the sending state of the purpose for the remission. So ito ay kasangkot nito ang kanilang personal na ari-arian sa bansa. So kung saan sila nagtatrabaho maliban kung hawak nila ang ari-arian na ayon sa ngalan ng kanilang sariling bansa para sa kanilang diplomatikong misyon. And B, an action relating to succession in which the diplomatic agent is involved as executor, administrator, or legatee as private person and not on behalf of the sending state. So this means like ito naman ay isang legal na action, talks about like being tagapagmana or mana, ngunit hindi sa ngalan ng kanilang sariling bansa. And C, an action relating to any professional or commercial activity exercised by the diplomatic agent in the receiving state outside of his official functions. So, ang pangatlo naman ay ito ay kasangkot sa isang legal na ginagawa nila sa bansa kung saan sila nagtatrabaho, ngunit hindi bilang bahagi ng kanilang opisyal na mga tungkuling diplomatic. So these are the three. This is something like a situation like diplomats may not be protected from legal action in the country that they are working in, especially when it involves to their personal property, inheritance matters, or personal activities outside of their official diplomatic duties. So let's go to the consular officer. So consular officer does not enjoy immunity from the criminal jurisdiction of the receiving state and are amenable to the jurisdiction of the judicial or administrative authorities of the receiving state in respect of acts performed in the exercise consular function. So this means like, so ang consular officer is a person who works at a consulate to help people to go back from their home country who are living or traveling in another country. So, however, this does not apply in respect of a civil action either. So also there is some certain situation where a consular officer cannot be held for responsible or in a legal case. So number one ito is arising out of a contract concluded by a consular officer in which he did not enter expressly or implied me. So this means that if the officer did not agree to a contract either directly or indirectly. And number two, by a third party for damages arising from an accident in the receiving state caused by a vehicle, vessel, or aircraft under Vienna Convention of the Consular Relations. So this means like if a third party is trying to sue for damages from an accident in the country where the officer is working caused by a vehicle or boat or subplane. So let's go to the diplomatic relations. So there are grounds for termination of diplomatic relations under municipal law. So number one ito is resignation. So when you said resignation, so this means that if a diplomat or ambassador voluntarily decides to leave their position, which can lead to the termination of diplomatic relations between countries. And number two naman ay accomplishment of the purpose. So this means that when the original reason for having diplomatic relations has been achieved, such as resolving as a conflict or signing a treaty. And number three, death. So if a diplomat or ambassador passes away. And then number four, abolition of the office. So this means like if the government decides to get rid of the diplomatic office or position responsible for maintaining relations with another country. And number five is removal. So this refers to the removal of a diplomat or ambassador from their positions. So there are also grounds for termination of diplomatic relation under international law. So number one is war, which is outbreak between the sending and receiving states. And number two, extension of either the sending state or the receiving state. And number three, recall, demanded by the receiving state when the foreign diplomat become persona non grata. And that's all.
Treaties. A treaty is generally generally defined as an agreement between and among states by which parties obligate themselves to act or refrain from acting according to the terms of the treaty. However, under the Vienna Convention on the Law of Treaties, or VCLT, a treaty has been defined as an international agreement concluded between states in a written form and governed by international law, whether embodied in the single instrument or in two or more related instruments and whatever its particular designation. There are essential characteristics of a treaty. The first one, it becomes binding on the parties and parties to it by virtue of their consent. And number two, while treaties will in most cases be written instrument concluded between states, the term applies equally to unwritten agreements and to agreements between states and international organizations and between international organizations. There are approbation of a treaty, and it may be number one, purport to codify existing rules of customary law. An example of that is Article 55 of the 1982 Convention in the Law of the Sea, which provides for the recognition of the EEZ. The second one is crystallize a developing rule of law, firmly establishing a legal footing a situation which has previously been part of the practice of a limited number of states. Or number three, generate rules of the law independently on the previous practice of states. An example, prohibition. There are two kinds of treaty. The first one is the lawmaking treaty, which means lawmaking has received meaning in the context of treaties, and it refers to the substance of the norms which would be statutory rather than contractual. In the words of Sir Gerald Birch Maurice, lawmaking treaties stipulate integral obligations. And the Vienna Convention of the Law of Treaties defines a treaty as an international agreement concluded between states in a written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. And there are examples of the latter kind of treaty include range of environmental treaties such as the Geneva Convention on the Long-Range Transboundary Air Pollution in 1979 and the Vienna Convention for the Protection of Ozone Layer in 1985, as well as their succeeding protocols, the UN Framework Convention on Climate Change. The second one is the treaty contracts. Fundamental principles of the law of treaties. The first one is the principle of free consent. A state cannot be bound by treaty in which it has not consented. Second one is the principle of pacta sunt servanda. Literally means agreements must be kept. The principle of good faith, recognized as the foundation of the international legal order. States and non-states actors are required to comply with binding obligations imposed upon them by the international law, irrespective of whether such obligations derive from treaties, customary rules, or any other source of international law. There are essential requisites of a valid treaty. The first one, it must be written instrument or instruments between two or more parties. second one is the parties must be states within the meaning of international law or IL. The third one, it must be governed by international law. And the fourth one, it must be intended to create a legal obligations. Exclusions. One are those concluded between states and other subjects of international law. The second one is agreements not in writing. And the third one, those which are governed by the national law system chosen by the parties. There are usual steps in the treaty-making process or NISRA-ER. The first one is negotiation, conducted by the parties to reach an agreement on each terms. The second is the signature, the signing of the text of the instrument agreed upon by the parties. The third is the ratification, the act by which the provisions of a treaty are formally confirmed and approved by the state. The fourth is the accession. A state can accede to a treaty only if invited or permitted to do so by the contracting parties. Such invitation or permission is usually given in the accession clause of the treaty itself. The next one is exchange of instruments, ratification, and the last one is the registration with the United Nations. There are traditional methods of expressing consent to a treaty. First is the signature. The legal effects of signature are as follows. The signing of a treaty may represent simply an authentication of its text, where signature is subject to ratification, acceptance, or approval. Signature does not establish consent to be bound. Letter C, where a treaty is not subject of ratification, acceptance, or approval, but a state's signature will signify consent to be bound. The consent of a state to be bound by a treaty is expressed by the signature of its representatives when the treaty provides that signature shall have that effect, and it's otherwise established that the negotiating states were agreed that signature should have the effect or the intention of the states to give effect to the signature affers from the full powers of the representative or was expressed during the negotiations. The second is the ratification, a formal act whereby one state declares its acceptance of the terms of the treaty and undertakes to observe them. Ratification is used to describe two distinct procedural acts. A. Ratification in municipal law is the formal act of the appropriate organ of the states affected in accord with national constitutional law. B. Ratification in international law. Ratification is procedure which brings a treaty into force for the state concerned by establishing its definitive consent to be bound that particular treaty. International law is not concerned with the requirements of its constitutional law. When ratification is so required, a treaty provides for such consent to be expressed by means of ratification. Number one, it is otherwise established that the negotiating states were agreed that ratification should be required. The representative of the states has signed the treaty subject to ratification, or the intention of the state to sign the treaty subject to ratification appears from the full powers of its representatives or was expressed during the negotiation.
Accession or adherence or adhesion occurs when the state accession or adherence or adhesion occurs when the state which did not participate in the negotiating and signing of the relevant treaty formally accept its provisions. It may occur before after a treaty has entered into force. Protocol de closure. It is a final act and instrument which records the winding up of the proceedings of a diplomatic conference and usually includes a reproduction of the text of treaties. So next is applicable rules when there is a conflict between a treaty and domestic legislation. The rule will depend on which court is deciding. Number 1. International Court. International Court will uphold treaty obligation in general. A state may not invoke the fact that its consent to be bound by a treaty has been expressed in violation of provision of its internal law. Regarding competence to conclude treaties is invalidating its consent unless that violation was manifest and concerned a rule of its internal law of fundamental importance. A violation is a manifest of it would be objective evidence of any state conducting itself in a matter in accordance with the normal practice and in good faith. Number 2 is domestic law. Treaty versus Constitution. A constitution is always prevail. Treaty versus statute. When the two instrument relates to the same subject, the try to give both if inconsistent legal techniques to statutory construction will be employed. Some such rules say that the later time prevails more than the specific law prevails over the general. Grounds of nullity affecting the consent of a party to a treaty. Number 1. Corruption of representative of a state. Corruption must be substantial and lends a small courtesy of favor shown a representative will be insufficient. Coercion of a representative of a state. It must be directed at the representative personally or his or her family. Coercion of a state must be shown that the conclusion of a treaty has been procured by the threat or use of force. Manifest violation in international law. The alleged violation of a domestic law must concern fundamental provisions which relate to state treaty making power and must be evident to any state acting by normal practice and good faith. Number 6 Host-Cogens. If a new Host-Cogens emerges, any existing treaty is conflict with that rule become void and terminate. Ground of suspension of a treaty. A treaty may be suspended in 6 situations. 2 of them are where all contracting parties agree to suspend an operation of a treaty or some of its provision. Where 2 or more parties agree to suspend its operation temporarily between themselves provided this either allowed under the relevant treaty or not prohibited. The last one is the last two is ground for termination of a treaty. A party in following situation has a choice either to suspend or terminate the relevant treaty. Number 1, material breach of a treaty. Impossible for a party to perform its obligation. Rebus sic stantibus. All contracting parties to early treaty are also parties to a late treaty, and the two treaties relate to the same subject matter. Termination versus suspension. When a treaty is suspended, it is still valid, but its operation is suspended temporarily, either for all the parties or some of them. The other hand, when a treaty is terminated,